Welcome everybody, I'm Jill Cox with Heritage Title. Thank you so much for joining us for this month's industry update. I wanted to just quickly give you some information. We've got a lot of updates coming up already pre-scheduled, so save these dates. May 6th, we've got Marcia Waters. June 3rd, Pete Muccio, who's a landlord tenant attorney. July 1st, Liz Peets, who is VP of Government Affairs for Colorado Association of Realtors. And August 5th, Terry Williams, the VP of Underwriting for Heritage Title, is going to be presenting. So definitely save those dates. I'm going to stop my screen share, and I am not going to go into a big formal introduction today. These are two gentlemen who don't need any kind of introduction, but Scott Peterson, thank you so much for joining us today. You are real estate royalty. We really appreciate your time and expertise. And Damien, you're okay too. So thanks for being here, and welcome everybody.
I'm Scott Peterson's Ed McMahon is what I am, for those old enough to remember the Carson shows.
Oh, stop it, Damien. That's silliness. Thank you, Jill, and thanks for having me here. This is my I refer to these monthly sessions that Jill and Damien put together as fun family time with the Coxes, right? It gets pretty rowdy and exciting month to month, I know, and it just makes me wonder, how exciting and fun it could possibly be around the Cox family estate on the weekends. It's if they're able to have this much fun on a Wednesday or Thursday afternoon talking business, go figure. It's a pleasure, though, to be here. So thank you for having me on. Should I just get going? You want me to kind of dive into what I'm doing here?
Yeah,
Scott, why don't you talk about the stuff that, well, I know what you're going to talk about, and I'm sure that a lot of people have heard about this subject, but haven't heard a lot of what's come out of it since then. So if you go ahead and kind of talk about that, and then we'll answer questions and kind of go from there.
Yeah, so I know we might just have like half of our population of attendees drop off when I say I'm going to talk a little bit about antitrust, but trust me, hang in there, because there's a lot of impacts of this that are going to have an impact, I think, on your business, on our industry, and kind of how we do things as an industry. And there's a heck of a lot going on. It's an incredibly boring topic, and it wasn't even until about 2 years ago that I had really much interest or real need to talk about antitrust. And then things started to get fired up. So, Jill, I'm trying to share my screen, and it says that I'm disabled from doing that. I promised when we were talking before that I wouldn't share anything inappropriate. So hopefully you can trust me just to share a simple PowerPoint. All right, there we go.
Again.
Hold on. Hold on 1 second here. As I mentioned this, there we go. There. All right, can you guys see that now?
Yep,
that works.
Perfect. Let me get that back. So anyhow, antitrust, not a terribly exciting topic historically. And we know most of the stuff, intuitively as an industry, and we've been trained, I think, really well as an industry over the course of anybody who's on this, session's career, I'm certain, about the concepts of, setting commissions and talking outside of your office about commissions, price fixing, group boycotts to some degree. We've had that. We've had that discussion. We've had that spiel for a lot of years, and so people have gotten very comfortable. And in some ways, that's a good thing, I think. But at the same time, a couple of years ago, this topic got really kind of pushed front and center. And I feel like in many respects, it's only kind of continued to get pushed. The ball continues to get pushed down the road, and this topic becomes more and more front and center. And particularly over a couple of developments that I'm going to touch on here specifically, there's going to be a real impact on how you guys do business, the discussions that you're going to, I think, need to be having, particularly on the buyer side with your clients about commissions. And I think those chats are going to get pushed a lot more front and center. And there's also going to be very soon coming up some pretty significant implications on the MLS and how listings are done and what information is public. And so I'm going to touch on a couple of things here. The thing that, and all of these are sort of based in antitrust, right? And I'm going to go a little bit out of order here. So this is NAR's slide presentation on this stuff, and I think it's pretty good. But I'm going to jump around a little bit. The reason in March of 2019 that we started talking about antitrust issues, again, as most of you guys know, there was a lawsuit that was filed in federal district court in Illinois, March, I think, 6th of 2019. I literally remember as I started reading about it being filed and reading the facts of the case that day. And kind of seeing the potential implications that were there. It was a case by the name of Merrill versus NAR, and then 4 co-defendants, Realty, Keller Williams, Home Services, and RE/MAX. So the large franchisors in the United States of America, 4 of the largest franchisors in the United States of America, were all co-defendants with NAR on that matter. And then a couple of, and this was a class action lawsuit basically, and I'm not going to get into the details because I think most of you know this, but based on this loose concept that generally speaking over the course of generations, literally, NAR and those 4 co-defendants through their MLS policies have essentially conspired and colluded to artificially inflate the commissions that a seller is effectively forced to pay to a buyer's agent in a real estate transaction. And that's the basic premise. And again, I'm not going to get into, unless you guys have specific questions, the real details of that. But it's a class action lawsuit based in antitrust law, federal antitrust law, that was initiated. And then a couple of months later, like 6 weeks actually, I think later, there was another lawsuit that was filed in Missouri, same exact allegations, different law firm that initiated the complaint and has been perpetuating the complaint. And that was the Sitzer matter, I think is how that's referred to. But that was filed in federal district court in Missouri, again, in antitrust, class action lawsuit, making essentially the exact same allegations. And this happens sometimes in these large federal type class action lawsuits where one law firm kind of develops this theory, finds an appropriate plaintiff, and then other law firms will kind of copycat the lawsuit along.
It's like serial killers.
Yeah, those dirty lawyers and chasing down the, yeah. So anyhow, it's not uncommon particularly when there's a deep theory behind it. And I'm not supporting the theory in many ways. I think they're just, in fact, I think they're dead wrong about most of their allegations, but nonetheless, there is some meat on the bone that has been seen. And so those 2 lawsuits that you guys have previously heard about, they were in March, and then I think in late May, early June of 2019. And then a little bit later in June of 2019, the Department of Justice issued a subpoena to CoreLogic, and CoreLogic is the backbone behind most of the MLSs in the entire country. And they subpoenaed them saying, hey, we want all of your MLS records, but we want you to focus specifically in your production on a couple of areas primarily related to cooperating commissions that are being offered. And nobody knew what was going on there. And unlike the lawsuits where you have to state in a civil lawsuit, you've got to state a claim, you've got to file a complaint and articulate what you're alleging and your alleged damages. The DOJ, the Department of Justice, if they open an investigation, they don't have to say anything. They just send out a subpoena, which is what they did. And CoreLogic complied with the subpoena. And people kind of assumed based on the direction of what the information they were looking for was, that it had to do with commissions and the MLS and kind of how all of that interplayed. And then we found out just the end of last year, kind of end of November, beginning of December. So it took a full year and a half, almost 18 months essentially, of this investigation going on, that NAR and the Department of Justice had reached a settlement, or the basic terms of a settlement, that was related to the subpoena that had been issued almost a full 18 months prior, and the investigation that was undertaken. And so essentially, the NAR had some antitrust concerns of their own. Once again, we're in this kind of theory of antitrust, and their concerns were that consumers were being harmed because a lot of information that should be available to them hasn't essentially been historically available to them, most specifically related to buyer agent cooperating commissions being offered. Those have always been hidden behind, typically, they haven't been a public data field in your MLS. So when you go to syndicate the information for consumers, one of the data fields that is almost universally not a public data field that wouldn't be available through syndication would be the offered compensation to a buyer representative. And so what they announced was that there was going to be this settlement that was going to be developed, and they're currently, as we speak, developing the terms of what will become a final settlement. They had said and they expected that to be done in the first quarter of 2021, and here we are on the last day of the first quarter of 2021, and they still have not released the basic terms of it. But what we do know, based on the joint announcement that NAR made with the Department of Justice, is they've essentially in principle agreed to a couple of different tenets that are going to be as a part of this settlement. And this is where I think we're going to see some real changes potentially in the industry. One of those things, and I'm going to kind of fly through some of these slides, but basically what this slide is saying is that the commissions will now need to be the cooperating commission, not the inside commission, not the commission agreement that you have as a listing broker with your seller. That's private information. You can always be that way. But the offered compensation to a cooperating broker that is listed in the MLS, now in any realtor-owned MLS, which is pretty much every single MLS in the entire country, including everything that we have here in the Front Range, the co-op commission will become a public data field. So when you hit syndicate on your listing, whatever percentage or dollar amount, and please guys, as we're asking questions or doing anything in the chat box, we're not using numbers, we're not talking numbers, that kind of cuts to the very heart of some of this antitrust discussion we're going to have. So please refrain from doing that in any of your questions or chat or dialogue. But that offered percentage or dollar amount that is to a cooperating broker will be a publicly syndicated data field. It's going to have to be, and this will become effective at some point this spring, most certainly across the entire United States of America. So that's essentially what this slide says. There's also going to be, as part of this agreement, a specific prohibition against any buyer's agents advertising their services as being free, right? Because the Department of Justice feels like that's not an accurate statement when you say, hey, work with me. It doesn't cost you anything to work with me if you're a buyer. The seller pays me. My services are free. Nomenclature of that nature is not consistent with what is actually going on, at least in the DOJ's view. And so that will become a part of the settlement that is going to be finalized, like I say, in the next couple of months. And then another piece of this is that, and most MLSs, and I don't even think any MLSs in Colorado but do this or have done it for a long time, but there are some MLSs where a broker is able to search as a filter what the offered compensation is for a cooperating broker. And again, I don't think for a long time any of our MLSs in the state have been able to do that, or particularly on the Front Range. But now it's going to be a specific prohibition that a broker, an MLS participant who is searching the MLS for properties, will not be able to filter those properties based on the amount of or existence of, it's the amount of any offered or cooperating compensation that's being offered. And then the last thing that's going to have an impact, I think, is this lockbox access. So every MLS is going to need to adopt a rule essentially that requires member boards or MLS, so association or an MLS, and showings are actually arranged in different ways by in different places in different ways, is what I'm trying to say. Sometimes it's done through the board, sometimes it's through the MLS, sometimes it's through the brokerage firm. But the point is that any licensed real estate agent or broker shall have access with the seller's approval to lock boxes of properties that are listed on the MLS. So if you're going to put a property on the MLS, no longer will anybody be able to have a policy to say, well, we're only going to provide lockbox access to listed properties on our MLS to participants of our MLS or participants of our local association. It would have to be granted to any licensed, and it would be in this state licensed broker. And again, that's with the seller's approval. That clause is quite meaningful. But in most cases, you've got to believe that sellers are not, they want to sell their house. They're not necessarily interested if the buyer's agent is coming from the local market or from some other market outside of that local market. In many cases, sometimes they might be, but anyhow, that's the other significant rule change that is going to be, that's going to go into effect. And again, this is going to be very, very soon. Nothing done immediately. We are going to get, I was expecting by the end of this first quarter, a look at the final agreement that's going to go into place. But those are the four big sort of tenets or components that are going to be in there. The devil's going to be a little bit in the details, particularly on that lockbox access one, I believe, but we'll see what happens. NAR will be approving these changes at their spring board of directors meeting, which takes place, I think, in about 6 weeks or so. And so I think we'll have an agreement in front of us by then. And then ultimately those final rules will be implemented, I'm guessing, over the next couple of months as MLSs will be forced to implement these changes. And then the implications, I think there are many. And I've talked to my friend Damien a lot about this over the last several months. We've been, kind of watching this and chatting, as we often do, about, how our industry is going to be affected by some of the regulatory and or legal things that take place. I'll start off, and then maybe, Damien, I know, has got a lot of thoughts as well, but as he always does. But I think one of the things that concerns me that I'm going to be monitoring, that I've been talking to brokers about, is this. I think that between the commission being syndicated. Now, remember, there's a difference between offering compensation. The offer of compensation, that will only extend to other participants within your MLS. So you have not made an offer to compensate anybody other than those participants within your MLS. But that data field being public, I think, is going to let brokers and or consumers from all over the state or wherever they're searching for the property know what percentage or dollar amount would be offered to their broker or to them if they were a member of that MLS. And so that piece of the rule change in connection with the lockbox access piece of the rule change, I think is going to result potentially in a lot more what I'll call traveling realtors or traveling licensees, brokers that are working with a buyer and they can go, oh yeah, I can look at, pick your syndicator, and I can look and I can see what the offered compensation is. And I know that if I take this buyer up to, a mountain property or down to a, Pueblo or up to Fort Collins or wherever it might be outside of your own expertise area or market area or MLS, you'll know what the compensation being offered is, and you'll also know that you can't be precluded from accessing with your client the lockbox unless the seller instructs otherwise. I think we're going to see a lot more traveling realtors. And that to me leads to some potential competency concerns. And Damien, you want to jump in and chatter a little bit?
Yeah, I think you hit the nail on the head, is that, they're putting in place these rules to allow, what it really is about is transparency, really. But I think it is going to create this conflict with our license law, and that we're going to have more and more brokers who think that, well, if I know what the compensation is, then I can just go wherever I need to go to do the compensation. And I know you and I have talked before that, buyer brokers in the past have just done such a poor job of explaining their value propositions. And if their offer of compensation is now syndicated and now people can see it, buyer brokers are going to have to do a better job of explaining what exactly they do for that commission. That's something that buyer brokers have just kind of assumed that they would be getting paid, and they just kind of ignore it and just, work the transaction. But it's going to be more and more important that people understand what exactly the buyer broker is doing in the transaction. And the reality is, you guys have a great value proposition. I mean, you really do. You have access to the MLS system. You can pull up comps. You can help them evaluate whether their property is a good find or a good buy or not. You give them referrals to different experts. You help them draft a contract, which obviously in my world, I think is the most important thing that you guys do. You give them legal advice on that contract. But, buyer brokers, it's going to be more important that they do those kind of things. To me, that's probably the biggest implication of this transparency initiative. And Scott, you and I have talked about that extensively.
Yeah, no, absolutely. So I think the traveling realtor is one piece of it, and the competency, how that all dovetails. But then to Damien's point, I think commission discussions between particularly buyer's agents and their buyers related to what the buyer's agent is getting paid and the amount of the commission is going to be a much more forward discussion than it has been previously. And that also goes to the whole concept of this: your services aren't free, and the prohibition against advertising services for free as well. I think I use an example, and I talk to people on the car legal hotline and realtors all over the state and have for many years. I think there's three different categories, broad categories of realtors or licensees. There are your realtors who do not have a value proposition, right? That's one category. And there's plenty of them out there. Some of you probably are thinking, like right off the top of your head, like I can picture a handful of them that don't have a value proposition. Well, guess what? The market is going to get really, really challenging for those people, I believe, and it probably deservedly so, because if they're not and have not been bringing value to the table, they're going to have a harder time. But there is that category, one of those three categories. The second category of brokers that I can identify is brokers who have a value proposition, have a very good value proposition, and they've got a really, really good ability to sell and articulate that value proposition. And those are going to be your successful brokers in any market under any circumstances. They're your biggest and heaviest hitters, your top producers are that second category. They bring value to the table and they are really good at articulating and selling that value to their consumers, to their clients, their customers, and that's what wins them the business. The third category of brokers that are out there, and this is the category that I'm the most, sort of sympathetic or empathetic to, is those that have a value proposition, but they don't really have a great pitch. They don't do a great job at selling and or articulating their value proposition. And it's that third category that's so frustrating because you're doing all the right stuff on the deal, but if you haven't figured out how to really articulate your value proposition, you're not moving into that second category. And I think being in that second category with these changes that are coming down is going to be that much more important than ever. And again, this is mostly referring to the stuff on the buyer agency side of things or buyer broker side of things. The listing agent, it's a little bit more, I don't want to say easier to sell, but it's your value proposition is almost easier to articulate because of the marketing aspects of what you do that are so unique and so difficult for a consumer to try and do as a for sale by owner or something else. I think most people realize that they're going to fail or not be able to get the full value on the seller side of things. But anyhow, be thinking about those categories. And if you find that you're in that third category where you do a great job, you're attending sessions like this, you're studying and you understand contracts, and you bring all those value, those aspects of your value proposition, but you're not great at articulating it, figure out what yours is, because it's not going to be the same for every one of you guys. They're different. Different people, different individuals bring different value propositions to the table. And so anyhow, keep that stuff in mind, because I do think it's going to be an important discussion for you and your buyer clients, particularly as commissions and the amount of money that you're getting paid is going to be, front and center on any information that they receive, wherever that information comes from going forward.
Hey, Scott, I want to back up real quick to something you said, because I think it's worth, highlighting, is that, this transparency across, whatever the platform is that you're seeing these offers of compensation, is really for the consumers and is not an offer of compensation, because I can just, that's something that's just going to be a huge, I potentially see, well, you're going to be busy. Let's put it that way, with the arbitration and procuring cause and who's entitled to commission. I mean, we already have problems with the contract now, that people think that because they put something in compensation in the bottom of the end of contract in the commission approved form, that they somehow have a claim to commission. And, now it's going to be even worse because these things are going to be published, so if you're a buyer broker and you are in an area that you're not a member of and offered a co-op commission, or there's not an offer of compensation, keep in mind, you're going to need some kind of commission agreement to make sure that you're getting your compensation, because just because it's now being syndicated doesn't mean that you're entitled to it, which is it's going to be a big gotcha for a lot of people.
Yeah, thanks for saying that. We had an arbitration this week, a procuring cause arbitration through CAR on an issue related to out-of-market broker and offer of compensation. I'm going to guess we've probably got 4 or 5 arbitration requests that are in arbitration scheduled that are in the hopper over the next several months that we're going to be hearing. I've been seeing a ton more arbitration complaints or requests related to out-of-market broker who are, they received the settlement statement that, a couple days before closing, and they see that they're not getting compensation, and then they're either calling the hotline usually is how I get them from the very beginning, and say, well, wait a second, I saw that the listed commission was X, but now they're giving me Y, or now they're not paying me anything at all. What do I do? And I say, well, you get paid as a realtor or a broker in one of two different ways. You either get compensated through an express agreement, and it could be written or verbal. Verbal's not great ever because you've got it's a matter of proof or evidence. It makes it tough. Written commission agreement's just fine, and it's an enforceable contract. The other, and that could also be done through the contract between the buyer and seller, but you got to be very careful how you're doing that. There's only a very narrow way that you're able to actually, or that your buyer is able to actually instruct the seller to pay you through the contract to buy and sell. So that's one piece, is through an agreement. The other piece is through a non-contractual relationship, and the only one of those that I know of comes through the offer of compensation that is embedded in your MLS agreements. And so if you don't have that mutual participation in the MLS, that's going to make sure that you're compensated based on a compensation agreement through your MLS, then you better have something, most preferably in writing, if you expect to actually get paid. So do be mindful of that, and please do, because the volume of arbitrations and problems that we're seeing as a result of this is pretty shocking, actually. And I've seen a real increase. I expect that we'll be seeing more. So thanks for bringing that up, Danny.
Would this be a good time to go through a couple of quick questions?
Sure.
Okay, I'm going to start with most recent, kind of work my way back, so we'll try to address everybody's questions. So for the traveling real estate broker who is not participating in the local MLS, how is their brokerage compensated with commission, as there is no compensation offer? Is there a form, email correspondence enough? What if the traveling broker does not address? Is commission owed to their brokerage?
So do you want me, Scott, or you want to go?
Yeah, go for it. I think I answered some of that just a minute ago, but yeah, you go ahead.
Yeah, I just want to address it quickly, just because. So I saw that this was also, yes, the brokerage firm is the one that has to be paid on it. Keep in mind though that there's two kind of things at play here with the traveling broker. One question is going to be competency, which brokers, you guys don't get to enforce competency rules. The competency rules are a division of real estate enforcement mechanism, and it's typically because somebody breached an obligation to their client. So, so keep in mind that that's a separate issue, and that's a license law violation if you're not competent to be working in some of these areas where you're traveling to. That said, there are some traveling brokers that work in areas where they may not be members of an MLS, but that may be very competent. So I also don't want to put out there that just because they aren't a member of your MLS means they're incompetent, because that's not true either. But the best way I see to deal with this is how the division of real estate is giving you to deal with it, which is, have a buyer listing contract, check the box that says buyer is obligated to pay, and then put in how much commission that you're going to be receiving in the contract. And frankly, that helps deal with issues that are going to come out of this whole antitrust lawsuit, which may be a pressure down on commissions. And if you're good at explaining your value proposition and you have an expectation of X, but the listing broker is only paying Y, that's another mechanism for you to make sure that you're receiving the compensation that your buyer agreed to pay you. That was put in place a long time ago. It's been in the annual commission update course several times. If you don't know what I'm talking about, go talk to your employing broker. But I see that being probably the best mechanism for dealing with some of these commission issues where the offer of compensation, or there is no offer of compensation, is not what the buyer broker anticipated. But it does require that you have a brokerage or a buyer listing contract that says the buyer is obligated to pay.
Yeah, checking the right box, and first of all, getting that exclusive right to buy agreement executed is important for so many reasons, but also making sure that you're checking the appropriate box in paragraph 7 that indicates that the buyer would pay or will pay you if the seller doesn't, and it says seller may pay, which means that the buyer then could, in the contract to buy and sell, in the additional provisions, instruct you to put some language in there that would obligate, for the benefit of the buyer, that the seller is going to pay your commission. That's always going to be the best place to ensure that you're actually going to receive whatever commission you're anticipating in the transaction. But and then the other possibility would be some sort of a written commission agreement. And I don't know if I want to go into the wormhole, Damien, that you and I have talked about. I believe that brokers ought to be able to prepare their own commission agreements, because you are a party to that agreement. And so you could certainly, if you're going to be doing deals out of market, then I would encourage you guys to invest in a competent real estate lawyer to draft for your firm, brokerage firm use, a commission agreement that you guys can use in transactions going forward. That's probably the second best way. I still believe, and I don't know, Damien, if we even want to get into this, but I think as a broker, you ought to be able, since you are a party to the commission agreement, I think you ought to be able to prepare your own basic commission agreement for you. But the Division of Real Estate may have some questions or issues with that. Any thoughts there, Damien?
Yeah. So first of all, when you're creating these commission agreements, keep in mind it is for the brokerage firm and not for the broker. But you as a licensed broker for the brokerage firm have authority to create those things. At least I believe. And like Scott, I believe that you're probably a party to it, which means that you probably have a right to create that form. The issue I'm seeing is that there is some case studies. One of them's in the ACU for 2021 that indicates that maybe or maybe not the commission might take issue with you creating your own forms without having an attorney draft it. So for many reasons, my suggestion is to stick with the buyer listing contract and have the appropriate box checked. If nothing else, I think they become more important now as you're going to have those conversations about compensation with your buyer. And this is really going to be the best way to make sure that you and your buyer are on the same page as to what you're getting paid and how you're getting paid. As we see the settlement of this antitrust stuff kind of play out, I think buyer listing contracts are just going to become more and more important. I mean, that's just my sense of it. But Scott, I don't know if you have any thought on that or not.
No, absolutely. I've said, first of all, I have a personal preference for an agency relationship, and the only way that can be created is through an exclusive right to buy, or an exclusive right to sell. And those documents protect our members, you guys, realtors, licensees. You guys work too hard. I can't tell you the number of hotline calls that I get, and I feel terrible for brokers who are acting as a TD, or they're probably more acting as an agent, but they've never established an agency relationship. They don't have an exclusive agreement. And then they find out in most cases that their buyers are cheating on them, or in many cases, their buyers are cheating on them. They go and purchase or write a contract with another broker, with their family member, on their own, directly with the seller. And now they're calling and saying, hey, what do I do? And you guys work way, way, way too hard to not expect and demand that your clients are offering you some manner of exclusivity as it relates to your relationship. And anyhow, but yeah, all of that can be taken care of in the agreement. Jill, are there more questions?
Yeah, so a follow-up to what you were just discussing, then will that allow us to ask for the seller to pay in additional provisions or ask for the higher commission versus a flat fee?
So, yeah, I mean, if you have a buyer listing contract that says that you're entitled to Y, and the offer of compensation from the seller is lower, whether it's a variable, flat fee, whatever you want to call it, your buyer has an obligation. They have an obligation to pay you what you've negotiated with your buyer. And I can see where a buyer would say, look, I don't want to pay that. I want you to shift my obligation over to the seller. And so, yes, that makes that commission now negotiable between the buyer and seller, as the buyer says, look, I don't want it paid I don't want to pay this. I know I have the obligation. I know I'm obligated under my buyer listing contract, but this is a fee that's typically borne by the seller, and I want you to shift it over to the seller. And so that's exactly what this does. If you have the buyer listing contract figured out correctly, it gives you that opportunity to have that negotiation in the contract.
Yeah, I would just add, please understand though that the only way that is acceptable under our licensing framework is if the buyer is obligated to pay you. If they are not obligated to pay you and you are using the contract between the parties to try and memorialize your fee, that is a explicit rule violation and just cannot be done. So make sure you're doing it the correct way if you're going that direction.
Yeah, and if you have questions about this, please talk to your employing broker, or if you have an attorney that represents your brokerage firm, talk to them and make sure you understand what that rule says, because it is a nuanced rule and you want to make sure that you're doing it correctly.
Question here, do you think consumers will want to go without a buyer agent and go directly to the seller and want a price reduction equal to the buyer broker compensation?
I think that's another offshoot of what might happen here. Is I think we might see more situations where you as a listing broker are being approached because through the syndication of your listing, the buyer consumer who, as we all know, I mean, they're out there using all of the syndication sites and all the resources that are available to them. And if the offered compensation is popping up on all these properties, I think there's a very, very good likelihood you're going to see an increase in buyers coming directly saying, hey, I want you to either act as a TV or treat me as a customer. And I want a purchase price reduction in the amount of, the offered compensation, or I want a seller concession, or I want, their credit, or whatever you might have. And I do think that's a very high likelihood of that phenomenon increasing.
So another question here. Both Metro MLS systems have had two co-op offer fields, one for agent and one for transaction broker. Can you explain why? Many have seen many odd use and interpretation. Any change with this new change?
Yeah, Scott, why don't you explain why?
Can I have this one, Damien?
Yeah, please.
We're laughing because we've laughed about it a lot over the years. First of all, to me, it's nonsensical. I don't understand why a seller cares whether the individual representing the buyer is the buyer's TV or is the buyer's agent. It makes no sense to me. And in fact, I would say, if anything, let me back up. So in most cases, when I see that distinction, that variance between what an offered compensation is to a buyer's agent versus a buyer's TV, it's most often more money, a higher commission being offered to a buyer's agent. And so that's where I say, in fact, that's nonsensical, because if I'm the seller, I would be offering more money to a buyer's transaction broker, who presumably, if they're actually adhering to the brokerage relationship, they are, as a transaction broker, they're not fighting for their buyer. They're not advocating for their buyer. They're not advising their buyer. They're a paper pusher, right? And so if I'm a seller, I would think that my listing agent and myself could take better advantage of a buyer who is only being represented by a TV versus an agent. So logically, as a seller, I would be incented to offer more money to a buyer TV than I would an agent, but that's the exact opposite of what ends up happening in most cases. So the distinction, the history behind that, I think Damien's got a little bit of perspective and history maybe on that. It's a silly distinction that, to my mind, it just could be avoided, because I cannot articulate a reason that a seller would care more or want to pay more to a buyer's agent than they would a buyer's TV.
Yeah, I mean, I know the theory behind it. I mean, the theory behind it is, oh my gosh, if it's a TB, then they don't help as much with the transaction and they're not as interested in whatever. And I totally get that. But at the end of the day, I mean, when you're negotiating terms of commission, that really is the seller's off, it's the listing broker's offer of compensation that they're giving pursuant to the contract with the seller. And I just don't see why a seller cares. And what it usually means is it's the broker that cares. For whatever reason it is, they care about what offer they make to these other people. And it really doesn't make any sense. I mean, at one point we looked at taking this out of the listing contract and changing it so that it was just an offer of compensation. I think we decided against that just because, less negotiation of commissions just doesn't seem appropriate, particularly in the world that we're living in. But I still don't understand the difference. I don't understand why anybody would do it. It really makes no sense to me. I mean, if you're a broker, take care of your client. And taking care of your client means making sure that you can get stuff under contract. And if I get that buyer brokers, I mean, I think you make the argument that some buyer agents don't engage as much as they should either. So I just don't see why offering one less than the other makes any sense. So I would not make a distinction if I were you guys.
Yeah, I think it would have come out of the exclusive right agreements. In fact, I think in Forms Committee, we kind of had chatted at our January meeting in 2019 or February meeting in 2019 about just removing it entirely. And I think everybody was in sort of agreement that it made sense. And then, as I mentioned, March of 2019, the very next month came up and the antitrust lawsuits hit, or the first antitrust lawsuit hit. And I remember that March Forms Committee meeting, the very next meeting, we kind of had a discussion like, well, why don't we just leave it, because we don't want to have less of a negotiation between a seller and a listing agent regarding commissions. And so it ended up staying, but I think it would have gone away. And frankly, I agree with everything else Damien said. It shouldn't be used, and I've never understood the reason why.
There's a comment here that the problem we have is agents are quote unquote transaction broker, yet their actions are that of an agent.
The secret agent.
But like I said, that's a violation between them and their client. Represent your client. Your job is to help your client get to closing. Your job is not to enforce license law with the other person and their client. So just
Yeah, but let me follow up on that, because I do think it's an important point and it's lost on a lot of people. If I were to ask you, if you're an agent for a buyer and you only gave them the uniform duties, you disregarded the fiduciaries, would that be a license law violation? I'll ask Daniel because he knows. Yeah.
If you were supposed to be an agent and you didn't provide the fiduciary duties, of course, it'd be a violation.
It's a violation of license law because
Absolutely.
you're not respecting the brokerage relationship that you have. All right. So, and everybody knows that. I think it's no big shock. But similarly, if you're a PV and you're acting as an agent, is that a violation of license law?
Of course, you're offering
Yes,
more than you're supposed to.
It's the exact same violation of license law. You're disregarding the brokerage relationships under the Brokerage Practice Act. And so, but everybody does it. And this is another way that you're going to get more exclusives signed, in my opinion, and become an agent more often, is when you're good at having a conversation with your buyer to say, hey, I need you to sign this agreement, this exclusive right to buy with me, because you want me to be your agent, and I can't be your agent if you don't sign an exclusive right agreement. We can't create that under a brokerage disclosure or without a writing. We need to have a writing for me to be your agent. But if you want me to advocate for you, if you want me to fight for you, if you want me to advise you, which every buyer does, every one of your clients do, they don't want you to be a paper pushing TV. So, but if you're not having that conversation, then it's easy for them. If you're not having that conversation, then it's easy for them not to sign something. But more importantly, if you're not having that conversation and you are still driving around with that buyer with whom you've only given a brokerage disclosure to, and you're saying, oh yeah, this listing's underpriced or this listing's overpriced. All of that is advocacy and advice. And you're breaking license law and doing all of that, but nobody seems to realize that. So keep that agency discussion in mind as you're trying to figure out ways to encourage your buyers to give you the exclusivity that comes along with that agreement.
And that is a whole lot of not antitrust.
No.
We have a lot of really good general questions in the Q&A. Scott, did you have more? Do you want to go ahead and wrap up the planned information and then we can jump into kind of a general?
Yeah, I'm just going to fly through and just finish up just real quickly. Other stuff on the litigation side. I mentioned to you guys the Moral and Sitzer matters. These were those the first two class actions. Moral was filed there, you see, in March of 2019. And well, it doesn't say that. And then Sitzer was filed a couple months later, and that's in Missouri. NAR and the co-defendants that I mentioned, those 4 co-defendants, they have all filed motions to dismiss. Those motions to dismiss were denied in both of those matters. And so these 2 matters are proceeding forward, and they're in discovery phases. And stay tuned. I mean, a class action, a big federal class action lawsuit like this is a 8 to 10 to 12 to even 15-year kind of spectrum. So stay tuned to see and keep your eyes on these things. But again, both of these are based in classic antitrust collusion kind of theories, and important, again, as an industry, that we're avoiding these collusionary conversations, the group boycott conversations, because the spotlight is upon us, so to speak. And then 2 other matters. Now, these are, again, class actions as well, filed in federal district court, but these are buyer class actions. So now Leader was filed back in January of this year in the same court as the Moral matter, the Northern District of Illinois. And then just about a week and a half, 2 weeks ago, in the Northern District of California, there was another matter, Conti, was filed. And so that's against the San Francisco Association, but it's also NAR. It's all of those same 4 co-defendants that I mentioned before. And they added as well, I want to say, Compass and Sotheby's to their action. So there's even more defendants in there. These 2 theories are similar theories, but these are representing buyers as a class who are suing those defendants and co-defendants, alleging that because of the mandatory offer of compensation to buyer's agents, that effectively buyers do pay those fees. And because of that, over the course of time, the cost of the transaction has increased. And their allegations are that buyers, or their belief is, or the foundation of their lawsuit is that buyers should be paying their own commission to their own broker. Well, that makes a ton of sense, considering that most buyers are trying to scrape together every nickel and dime in order to pay for their down payments and other things, moving costs and so forth. So these are two other side of the class actions, and they're brand new as of this year. And we'll see. They haven't even gotten to motions to dismiss, but we'll see where they go.
I'm kind of excited about those because I really want to know how the buyers in these cases with the straight face are going to say, I would have much rather paid my buyer broker than have the seller pay it on my behalf. I don't know any buyer that would ever say that, but I guess it'll be interesting to see how they.
Well, there's a buyer who has said that by the name of Leader in Illinois, and a buyer by the name of Conti in California that have managed to say that in some way.
You mean in hindsight, they're saying that, right?
Yes. Yeah. Well, so anyhow, again, both based though in antitrust. So I'm going to kind of wrap that up. Oh, on two other pieces, clear cooperation. These were two other class action lawsuits that were filed against NAR related to the clear cooperation policy. Both of them challenging the legitimacy of clear cooperation. It was a Top Agent was one, and PLS.com versus NAR. And they were both basically saying, hey, the clear cooperation policy is antitrust. It keeps us out of the market. They had business models that relied on a lot of free marketing of listings that would now be precluded based on the implementation of the clear cooperation policy. In both of those cases, NAR responded and they got both of those dismissed. So on the point of clear cooperation policy, and I get a ton of questions on this on the hotline and other places, that policy has been upheld now in two different matters in terms of being A-OK. So I think whether you like it or whether you don't like it, it's around for the time being. So that's it. I'll stop sharing my screen and we can talk about anything else that anybody else wants to talk about.
Yeah, I'm sure that we have a bunch of questions. I saw some coming in early on, Scott, that have nothing to do with your topic, but I think they're timely because it's about the market. But I'll let Jill, you want to go ahead and go through them and
I'll just work my way through here. No, we've got some great questions here. So first of all, any updates on evictions? Does that expire today or is it being extended? Contacts for attorneys to get my tenants out.
It's been extended to June 30th. Is now that's a federal extension. I think the governor stopped extending our state moratorium back in January, and they've been sort of relying on the CDC or the federal moratorium that has been substantially challenged. But nonetheless, it currently goes through June 30th of 2021. So we'll see if anybody ever has to pay rent or comply with their lease again.
Well, yeah, what's funny about that is there was two actions where the federal judges actually said that the eviction moratorium was unconstitutional. So I don't know about you, Scott, but I was a little surprised that they extended it because I figured they kind of let it die and then just kind of let the whole legal issue die. But I guess maybe we're going to see an appeal on this or something. I don't know what happens.
I don't know either. I wasn't surprised that they extended it just based on everything going on. It's just it didn't really seem to surprise me, but there definitely there's some legitimate constitutional challenges to it that have been that perspective has been affirmed, as Damien mentioned it, in at least two different matters.
Okay, if a buyer allows a seller to stay in their home with a post-closing occupancy agreement, can the seller then use the COVID eviction moratorium to stay in the house past the end of the PCOA?
Great question. No idea.
I say yes. I mean, that post-close not. I mean, listen. Here's the reality of it. This is what I tell people. If the seller / tenant doesn't move out at the end of or whenever they're supposed to deliver possession, what are you going to do? How are you going to get them out? You're going to
evict.
You're going to evict. There's no other physically other than I mean, you could send over send over some big guy like Damien to drag him out of there, right? Some tough guy. There you go. But you're gonna call the police and say that they're trespassing. Well, the police aren't going to do anything, and they're probably not trespassing. They're going to say, call the sheriff. This is a civil matter between two different parties. You're going to call the sheriff, and the sheriff's going to say, hey, great, we're happy to be scheduled to come out and evict, but she's going to give us a writ of restitution or something signed by a judge that instructs us to do that. And so you're in the eviction process, and then it's anybody's guess. But I think in most cases, an eviction judge is probably going to treat a seller / tenant as they would a tenant / tenant, unless there's other evidentiary facts or other things involved there. So do be cautious on those PCOs, because I think that could end up being, now the good news is that theoretically, at least, somebody who was a seller might have some pockets to actually pursue for the damages that as a tenant they may have caused. And by damages, I don't just mean physical damage to the property, I mean the civil damages that they would have caused, including the failure to deliver possession timely and whatever penalty may be listed in there, as well as attorney's fees and some other things. So
Yeah, the one thing I think everything Scott says is spot on with, in particular, if you're representing sellers, you got to warn them. This is a real risk to sellers or to buyers. I'm sorry. You got to warn buyers. This is a real risk that the seller may not vacate. The one thing I will say is that, you know, the eviction moratorium is based on COVID-19 hardships and different things related to COVID-19. So the seller would still have to prove that that was the reason. But I think it's a coin toss when you get in front of a judge as to whether or not they evict them or whether or not they let them stay. I mean, it just all depends on how compelling the buyer's argument is as far as why they need to leave. And I do think a judge could look at it and say, hey, seller, you know, you sold this property. This wasn't really a normal lease with an expectation to stay in a property. This is a little different, and they might issue a writ. But it really is anybody's guess. I think it's a coin toss, and you better be telling your clients that there's risk on both sides.
yeah, I would say that a seller/tenant would be less empathetic than maybe a pure tenant would in the judge's eyes. So that might have some bearing. The only other thing I wanted to mention is that in order to take advantage of the CDC protections, a tenant has to sign, and it's a federal form that's a CDC, and you can download it and just Google it, CDC eviction. Is it a disclaimer? It's not a disclaimer, it's simply a representation or warranty. And they've got to make these certain affirmative acknowledgments under penalty of perjury. But what was interesting is I saw when they extended the moratorium, the eviction moratorium a couple days ago to June 30th, they actually expanded the categories that was available to, and that's anybody who thinks they may have been exposed to COVID. And so if you expand that category, think about the implications of that. I literally laughed out loud when I saw that they not only forwarded the moratorium, but they expanded to anybody who thinks they may have been exposed to COVID. I mean, how sort of amorphous is that? And so if that's one of the categories that you would certify, then I think it's pretty broad in terms of trying to say, hey, this is COVID related. So
Yeah, I think it's concerning. I saw one of the brokers commenting, he thought CDC orders for non-payment. I'm not sure it's that narrow. I think it's pretty broad. More importantly, I think a judge could broaden it if they wanted to. That's why I think there's risk to everybody.
There's a question here to discuss the current guidelines for open houses.
I'm going to go ahead and put something in the chat here. And this is the FAQs that Dora came up with at the different levels. And Scott, I'll let you opine on this too. But the thing that I've found is that the Real Estate Commission's website has once again changed, because once you get used to where everything is, they like to move it around on you. The only thing you can find if you search is like red level, and it's ridiculous. But if you go here, this is Dora's site. There's a drop-down menu for real estate, and it has the FAQs for every single level as to what the requirements are. And to me, the FAQs are probably the best interpretation of the order as far as what you can and can't do. Frankly, Steve, to your question, the simple answer is nothing really changes at any of these levels for most anything that we're doing. It's all pretty much the same. There's some lightening of how many people can be in houses and how many people can be in offices and things. But otherwise, all of the indoor events requirements and all those other things that we've been doing since level red are the same at level blue and even level green, I believe. What do you think, Scott?
I agree 100% that particularly as it relates to open houses doesn't change much really between level. I have to look at level green, and Damien's got the FAQs for it, but I don't think it changes even between level green and level red really a whole lot. Obviously, we had that level purple threat that never materialized, thankfully, and I think they would have gone away there. But I mean, the short of it is you're stuck doing, directional signage, trying to come up with occupancy limits on a per room basis, meeting OSHA standard for air circulation, which I have no clue what that even means. And so I think what Damien and I have both been telling people is, I think it makes the most sense if you're going to host an open house to try and contain it to one party at a time, one group at a time, as opposed to just having a true kind of open house. And I think that makes the most sense in most respects. And as a broker, kind of takes the obligation off of you to be doing how many people are in this room and worrying about who's going up the stairs while somebody's coming down the stairs and all this other, you know, directional flow stuff. But that spans, I think, pretty much all of the color spectrum, those same requirements.
All right, so going back to our discussion with regards to the transaction broker, do you think the listing agent is just confused and thinks the lower commission is if they are double ending the deal?
I'm not sure I understand the question. I mean, are you following what the question is there, Scott?
No, where is the timing on that question?
244. Does that help you?
Well, no, I've got a whole list. I haven't been really following along. I was just trying to see the question so I can read it. Sometimes I don't exactly understand the question. I'm sorry.
Yeah, Holly, do you want to retype that and we'll come back to it? Sorry.
Yeah, I just don't follow.
I think somebody was kind of asking a question, speculating on the different, like why some people might use the variable commission to our earlier discussion related to a buyer TV versus a buyer agent. But I don't understand how to answer it exactly.
Somebody commented, I have seen listing agents who think if they are double ending the deal, then they are getting the transaction broker commission.
Well, I mean, the commission is all paid to the listing brokerage firm. You guys got to remember the full commission amount in there includes the co-op fee. So if there's no co-op broker, the full amount goes to the listing brokerage firm, period. So I mean, unless you have something additional provisions that changes if I'm not paying a co-op commission, that the commission's variable and I'm paying a lesser amount or something, the full amount is the full amount that's paid to the listing brokerage firm. The question is whether or not they're giving it to somebody else or giving a portion to somebody else.
Yeah, she followed up just saying she understands that. She's just saying there are agents who don't understand what a transaction is.
Well, that certainly could be, but you know, I can't help them. So
the other thing I'll just point out that's kind of a derivative of this from a listing brokerage standpoint is make sure you understand as well that just because you're an agent for a seller and an unrepresented buyer, or you're going to double in the deal, that doesn't mean that you have to become a TV, right? You can always give that buyer a customer disclosure and remain the seller's agent. And I think that's something else that I find that in talking to brokers on the hotline and other places that I don't know that they all understand, that they assume that if they're the only broker on the deal that they have to be a TV, and that is not the case whatsoever. And there may be a lot of good reasons for doing that.
And I'll tell you, my preference would be this: they are not a TB. If you start as an agent, you don't have any duty to the buyer or any relationship to the buyer. I would prefer that you do not change to TBD and stay agent and customer.
Yeah, it could be challenging to move from an agency relationship to a TV. I mean, think about, you know, if you're a seller's agent, you've been putting the house on the market, you've been consulting with your sellers about pricing and staging and photographs and how to sell it and whatever. And then suddenly some buyer comes along who you've never met before in your life and never spent any time with, and you're just going to immediately take off your agent hat and then treat the two parties equally. I think that's a problematic switch in some cases. Now, not saying it can't be done. I'm not saying it can't be done legally and under our brokerage license laws, but I do tend to agree with Damien that it's safer certainly to just remain agent and treat the buyer as a customer.
If a TB is providing agent services to their client and the other agent cannot complain and should remain in their lane, who will ever file a license law complaint against the TB for overstepping their obligations? The client won't.
The lawyer, when the deal goes sideways, they'll claim that they acted as an agent. They'll go after him for fiduciary duties. They'll sue him for those things. If they file a complaint with the real estate commission, the real estate commission will take it up. I mean, if there's something that goes sideways on that deal, it's going to be scrutinized.
And the agent, I mean, here's the thing that I don't like. And it goes to Damien's point about the competency rule. We don't have a competency rule in Colorado to protect your markets, to keep other brokers out of your markets. It's to protect the consumer, and it's not yours to enforce. Similarly, And so what I say when brokers call me, a listing broker will call and say, oh, I've got this buyer's agent or buyer broker in my market. They don't know what they're doing. I think they're in violation of the competency rule. I say, maybe they are. Take advantage of them if you're the seller's agent. Take advantage of that opportunity. It's what you're supposed to do is do your best job for your seller, and don't let that interfere with the transaction. Now, to the extent that post-closing, you've determined that the buyer was harmed or that the industry was harmed or that somebody was acting incompetently, you certainly could file a complaint against that broker, and the division will investigate as to whether there could have been consumer harm or something. But don't let that get you caught up, because at the end of the day, your seller wants to sell their house for the highest amount of money in the best time frame or whatever they're looking to do in terms of their particular interest. And that's your job at that point in time, not policing the industry for competency issues.
All right, here's a question. What are the legal or ethical issues when an agent knowingly writes multiple simultaneous offers on several properties for a buyer who can't perform on multiple contracts, hoping only to get one offer accepted in this highly competitive market?
It's a license law violation. So the buyer broker has an obligation to disclose anything material they know about the buyer's finances to every single one of those sellers. And so if you're not putting in there, hey, we're making multiple offers, but we can only afford one, you're in violation. You get turned in, it's violation.
Yeah, it is a disclosure issue, and then it's also a legal issue. I mean, I know it doesn't happen because you can't, you can write 50 offers before any or 100 offers before they get accepted, but that'd be the time that you get a simultaneous acceptance, right? Or, somehow two sellers happen to accept both offers before one is revoked. To the extent that either or both parties became aware of that, I think earnest money is immediately due and non-refundable based on a breach of good faith. And so I think, there's the regulatory piece, which is, as Amy mentioned, it's a violation for brokers' failure to disclose an adverse material fact. And remember, we talk about, it's another point I'll just make, it's kind of an aside, but it's directly related. We talk about adverse material facts and brokers' disclosure obligations all the time as it relates to the listing broker on the sale of a property. We don't always talk about them because they don't come up a lot on the buyer side, but the exact same test, the exact same standard applies for you as a buyer's agent in terms of your obligation to disclose adverse material facts that you may know about your buyer and or about the financing or the transaction as a whole. And so just keep that in mind as well.
Okay, shifting gears. Go ahead, Damien.
I saw a question that I would really want to address in here that's talked about overlapping showings. If you go look at those FAQs that I posted in the chat, you are not allowed to do overlapping showings. So it's, again, you have to keep space between people and traffic patterns and it's disinfect between and all that other stuff. So you probably want to take a look at that. I know that everybody's pushing the limits on showings and open houses right now, but keep in mind, those rules are still in effect.
Yeah, unlike an open house where you could have overlapping parties, it does provide that you could. A showing does not provide for any overlap. And I don't think it's a good idea on open houses, but it's specifically precluded when it comes to an actual scheduled showing.
Should those be reported, those overlapping showing listings?
Yeah, God, I like starting with the employing brokers and the broker and reminding them of what the rules are and asking them to comply. I hate turning people in because a lot of times they just don't know what the rules are, or they think, oh, hey, we're at level blue, so it's okay, we can do this now. And they don't realize that it's not. So I guess my suggestion would be to start with warning them that, that's not what the rules are. By the way, the Real Estate Commission this month will be hearing a whole bunch of disciplinary actions. And for the first time since COVID started, there's several actions against people who violated the governor's order. And so we'll see what the Real Estate Commission does with those people.
Shifting gears a little bit, are there any upcoming changes to the commission approved contracts in the works?
Of course there are. Why wouldn't there be? It's job security. I don't know if we can really talk about them, but the contract to buy and sell is what's on the agenda for being changed. And I know Scott and I are both pretty thrilled with a couple of the different changes that are being proposed. We'll see what the commission does with it, but yes, you will have a new contract to buy and sell come January 1st, 2022.
All 4 new contracts, or 4 or 5.
Five,
All
I
of the
think.
contracts to buy and sell will be updated. But yeah, there's some really exciting and good, I think very good proposed changes that Form Committee is kicking around and that the commission will ultimately rule on, I think, at their June meeting. Is it June or August?
They might wait. Well, they might wait until, I guess it all depends on when the legislative session ends. But, you know, there's still some question about whether or not there'll be changes to the legislative session.
Stay tuned. There's good stuff, I think.
There's a comment here that Riverside, California has a lawsuit about the issue of the PCOA and the seller staying in the property. So I guess it'll be interesting to see what comes out of that.
It's California. Who cares?
Yeah, I
Sorry,
mean, it's impossible to draw a lot of lines because I have no idea what the terms or what's included in the California PCOA. I mean,
what their statutes are.
Exactly, and to Damien's point, it is California, and so it'll be wacky for sure. I say that as a native Californian, but I've been here for 20 plus years, so don't hold it against me.
It hasn't worn off yet.
There you go.
The wacky has not worn off. All right, last one. How about writing a per diem claim if not vacated on the move out date?
I think that's already in the post-closing occupancy agreement. I mean, there's something in there that already talks about if they don't move out on time, that there's a per diem that the seller agrees to pay. So just make sure it's enough.
Yeah, it's setting that high enough is the real key. And that I mean, it's kind of a liquidated damages sort of provision, or it's intended for that. And so your seller is going to have some pretty significant, your buyer is going to have some pretty significant expenses. They've got a full moving truck potentially. They've got nights in hotels. That could really add up. So if you're a buyer's agent and you're looking at that, you really do need to be thinking about making sure or trying. And in this market, listen, your buyer is willing to do anything and give free post-closing occupancy and not account for any of their what should be legitimate concern. I understand, but in a normal world, you do need to be accounting for that eventuality in making sure you're setting that high enough. The other thing I'll just mention on that point is I get this question a lot is I believe that when you're writing the contract, people that have a PCOA will have possession be at closing, and then they'll have a PCOA that carries over and beyond that. Date on that should be the expiration of the PCOA, right? Would you agree with that, Damien?
Yeah.
Yeah. And then that triggers the provision that Damien was referring to in the contract. It says failure to deliver possession by the possession date is what that is hinged on.
I think there's a per diem in the post-closing occupancy agreement too. So, take a look.
Oh, yeah.
Well, so that's the one I think governs once the post-closing occupancy goes into effect. Because one thing I have seen is people have a $300 or $400 a day in the contract, and then for some reason they put $100 in the post-closing occupancy agreement. The seller thinks they're going to go collect, and well, it's $100 a day. That's what the post-closing occupancy agreement says.
Yeah, and do those PCOAs like at the time of contract, not 5 days before closing? Because that's the other call I get all the time is the buyer wants the seller to pay rent, the security deposit, all these discussions that if they happen early on, you can avoid. By the time you're at the end of the transaction, everybody knows there's enough consternation and frustration between the parties that it's not the time to negotiate a new deal, a lease deal. So do that early and get it out of the way and get it done early.
Great advice. All right, there's one last clarification question here, and then we're going to sign off because we're over time here. So going back to the showings, if your sellers sign off and specifically allow overlapping showings in the listing agreement, are they then allowed?
Nope. Governor's order is clear. They don't say, oh, no overlapping showings unless the seller says it's okay. I mean, the rules are the rules, guys. You need to really look at those FAQs that we posted and see what the rules are within it. But this is not something you can contract around. This is governor orders that say this is what the rules are.
We had a couple more questions come in. Do you guys have time, or do we need to answer those offline?
I'll do another one too. I mean, I'm good. Whatever you guys need.
Okay, we'll do these last two and we'll move on here.
And then stop asking questions. Jeez.
I'm going to post in the chat again, the link again, so people can get it.
Perfect. Okay, I had a sale where the seller refused to pay a deposit, so the listing agent and I agreed to split that $500 deposit. When my buyer found out, they were furious and said I didn't have their best interests at hand and was in violation. I know they were just mad because they paid $50,000 over. Did I do anything wrong?
I would disclose that to my buyer if you're engaged in that way. If there's going to be some agreement that you're coming out of pocket, even though it's for their benefit, I would make that disclosure to the buyer.
Absolutely. How do you not tell them that's what you're doing? I mean, ultimately, they aren't being harmed. At least the two brokers are putting up the deposit that the seller had to put up. So there's something there for the buyer, but you can't not tell them.
Okay, and last one. What is the possession date on the contract when using PCOA, close date or PCOA date? Buyers get the keys on the closing date.
I think that's what I said. I put the possession date, I would put as being the delivery of possession of the premises, which would be at the expiration of the PCO.
Yeah, and by the way, the PCO has language in there that says that the buyer has access to the property. One of the things that we keep missing is that the seller's a tenant. Once they close the property, they are not an owner anymore. They don't get the conveniences and the of being an owner where they can exclude people from their property and they can do whatever they want on it. They're now a tenant that's subject to landlord rights. And if you look at the post-closing occupancy agreement, some of those rights include the fact that the buyer can access the property with proper notice. And if it's an emergency, they can just access the property. So yes, they get a key at closing. They're a landlord. They have rights to access their property. Anything else, Scott? Any parting words?
No, well, I will. This isn't really a plug for anything for CAR, but my pal Damien and I are going to be hosting in the next week or so, I think, the DMAR Excellence Award. And so I don't know if I should be plugging that or not, because it might be a complete train wreck with the two of us at the helm. But we will not be dispensing any legal information. I think it'll all just try and be a little bit of fun. But it's kind of our first stab jointly at doing something like this. But I think it'll be fun. And we generally ham and egg it pretty well together. So if you're interested in that sort of thing, check it out. Who's
the ham and who's the egg? That's what I want to know.
I don't even know what to do with that.
Yeah, we'll leave that there, Jill. Thank you.
Right. We'll sign off. Thank you so much, Scott, for your time today. You're amazing. Damien, you're pretty cool too. Thanks everybody for joining us. It was great having you on, and I'll be sending out a link to the YouTube video of this a little later today or tomorrow if you want to rewatch. And thanks again for being here, and we will see you next month for Marcia Waters.
Sounds great. Thanks, guys.
Bye.
Bye, guys.